just have a couple questions before we proceed. I don't understand the nature and cause of the charges. Okay, so
What is your
if the city is if they are the victim, I would like to.
I am in charge of this courtroom and you're gonna stop
We
me.
are in charge of the courtroom.
Marshall, would you show Mr. Martinez the inside of our holding tank? Can we go ahead and get him an age evaluation on this case? So we can determine whether he's competent to represent himself.
All right, hey, can y'all hear me? I know, I'm gonna, give me a second here, I'm looking at something, just wanna make sure y'all can hear me first.
This harassment is also.
Okay, good. Actually, I think what I'm gonna do is get a better mic.
I know they were going to come to get me answer, but I just want to get this story out there so people know the truth. I know the government assessment. It's a
Let's see if this will work and do a little bit better. Yeah, I'm gonna try and do this a little bit differently here. So I was watching a video just now about Joshua Martinez. For those of you who don't know, he's been standing up to the courts and other stuff. And he's been targeted so many times. Okay, is this a little bit better? Let's see if this works. It's working. Can you hear me? Or can you not hear me at all? Test, test. Can you hear me? Can you guys hear me now? Oh, okay, good. Is it less hollow? Okay. So that did work. All right. Oh, it's not from the mic? Well, crap. How about that? See if that works. I'm trying a different tactic here. From the mic in hand, no? Or is it the same? Either way, we'll get to this thing here. Okay, well, regardless, we'll just go ahead and do this. Hey guys, so first of all, for those of you who don't know, today is Constitution Day. And what that means is on this day back in 1787, the Constitution was signed and forwarded to the states for ratification, and that's why this is Constitution Day. So September 17th, 1787 is the anniversary of the signing of the Constitution, and it's something that that we should all really pay attention to and really understand. I carry with me everywhere. Now I haven't, well, it's here in my bag. Let me just pull it out of my bag. But I carry with me everywhere the Constitution with me. This is my pencil bag for class, or my highlighter bag. You know, every law student needs 1 million highlighters. And I do have 1 million highlighters. I can't show them to you. The drawer won't come out. But this is a very important document. One of the things I'm learning, so this semester, which is my second year, I'm taking a lot of classes that have to do with constitutional principles. And one of the things that I've noticed, at least, is that I tend to have an advantage over many of my classmates because I have read this. I've gone through and I've probably gone through a few dozen of these constitutions, these pocket constitutions, because I always have one with me. And I always read them, I highlight in them, I take notes in them, and it's just good to have and to understand, not just the amendments, but also the Constitution itself, because it creates the limitations of government. What this does is it establishes the rule of law. One of the things we don't quite always take into account is what really this means. It's not just something that's there to protect our rights. I mean, what it's supposed to do is delineate the authorities and responsibilities of the federal government. This is what created the Federalist Republic that we have. And by Federalist, we mean multiple types of governments and the relationship between the federal government and the state governments. And so if you don't understand this is what's important. If you don't understand what's in here and what Article 1, Article 2, Article 3 means, it's very difficult to go through your life and recognize when the government has acted outside of its constitutional limitations, okay? This is the rule of law. This is what determines what government can and can't do. One more quick thing. On my screen, it looks like everything's backwards. Is like the "Don't Tread on Me" flag. Can y'all read that, or is it backwards to you too? It might be a setting I need to fix in here. I don't usually do this on my laptop, so this is all new to me. But I'm gonna keep talking. Just let me know if it's backwards, and eventually I'll maybe try to fix it next time or something, because that does get annoying. But what I want to, okay, good. So the largest book that I have, as a law student, have had to purchase so far and use is this. This is my biggest textbook so far, and I think in all of the law school classes, unless you take like some tax laws, I would imagine, tax law courses, maybe those are a little bit thicker. But this is the constitutional law book, okay? And one of the things that the Constitution says in Article 1, Section 8, and I'm not going to read a whole lot of stuff, but I want to kind of, before I talk about this case of United States v. Lopez, I want to kind of tell you what's the name of the book? Oh, you don't, Bob, you don't want to buy this. I mean, I guess you do, but these are a couple $100, these books. But it's just called Constitutional Law by Chemerinsky. This is the 5th edition. It's just Constitutional Law. And the author is Chemerinsky. But these law books are expensive. So I mean, I guess if you got a couple $100, go ahead and buy one. You can probably get a used one somewhere. You want to get the most updated edition if you do buy one, because obviously the Supreme Court is making up the law as they go along, and some things might have changed if you've got an older version. So in Article 1, Section 8, the Constitution gives Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes, okay, to regulate commerce. And up until about the 1930s, this was meant to understand, the court ruled on Commerce Clause issues pretty well. And up until, like I said, the 1930s, it restricted the ability of Congress to do a whole lot of things unless it had to do strictly with commerce. And up until that point, commerce only included stuff going between the states. It did not include manufacture or production, because those things are static. If I'm a farmer, when I plant my seeds, that's done in one spot. When I harvest, it's done in one spot. This is all the means of production. When I'm creating a a shirt, all of that sewing and cutting and packaging is done generally in one spot. And the court has traditionally, again, up until the 1930s, ruled that up until the point where those products start moving in interstate commerce, the Commerce Clause doesn't apply. Congress can't overstep those bounds. Now, since the 1930s, and this began with Roosevelt's New Deal, since the 1930s, the court has broadened the Commerce Clause immensely to the extent now where the government using the Commerce Clause ostensibly can regulate just about everything. And that's what makes United States v. Lopez sort of an anomaly and opening up a new era of jurisprudence, or in other words, case law, as it relates to the Commerce Clause. And I know some of this is kind of boring right now. I just wanted to give you kind of a background of how we got to where we are, because believe it or not, the Gun-Free School Zones Act was argued under the Commerce Clause. And I want to dig into this because, one, I want to let you know some things you probably don't know about the Gun-Free School Zone Act. Now, it was passed originally in 1990, okay? And 1990, who was president in 1990? Republican or Democrat? That's right. So the Gun-Free School Zone Act was passed by a Republican, okay? Let that sink in as we talk about some of this stuff. And Indigenous Impetus, I'm gonna get into your question, okay? I'm gonna answer your question. So here's what happened in Lopez, okay? Lopez was a senior in high school. In San Antonio. So this is actually a Texas-related case, United States v. Lopez. And he had concealed a .38 caliber, I believe it was a revolver. I don't know of many .38s that aren't revolvers. So I just assume it's a revolver. I know there are .380s that aren't revolvers, but I don't think I've ever seen a .38 caliber or .38 special semi-auto. So, but anyway, he was carrying a concealed .38 special, this senior in high school, and someone anonymously ratted him out. Some snitch ratted him out, and they confronted him, Lopez, and he admitted, yeah, I've got a pistol. And this was in 1992. So I'm going to age myself here a little bit. That's the year I graduated high school. 1992. And he was arrested and charged under Texas law, okay? And under 4603, it is against the law in Texas to carry a firearm on the premises of a school. Well, what happened was the next day after being charged, the federal government decided to indict him under the Gun-Free School Zones Act. And what the act says is that you can't carry, what it said was that you cannot carry a firearm within 1,000 feet of the grounds of a public, parochial, or private school. And of course, he was inside the school. So what Lopez did was he challenged the constitutionality of the Gun-Free School Zones Act. And yes, criminals don't care about signs and laws. That's true. But in this case, the law was unconstitutional. Now, the federal law was unconstitutional. We can argue about the state law, but he wasn't charged under the state law. And that's a whole different argument. So I'm talking about federalism and the Commerce Clause today. And what has happened is you've got so up until this point, up until Lopez in 92, and this case was in 95, so I guess up until 1995, the court had expanded the Commerce Clause beyond recognition. I mean, if our founders were able to come back today, and you can read the Federalist number 11 and understand what they meant, what the founders were talking about when they were talking about commerce, and it literally had nothing to do with what is being used under what is being justified under the Commerce Clause today. But up until this point, I mean, for example, you've got a case where you got a farmer, Filburn, who back in 1938, I believe it was, or 39, Congress had passed an act that you could not farm more than, I think it was like 11 or 12 acres of wheat. And this guy was a farmer, and so he abided by that. But what he did, yeah, what he did was he grew 23 acres, or he grew more than he was allowed to, like double the amount. But what he did was he only sold the 11 acres of wheat that was under the law, but he harvested another 12 or 13 acres of wheat for his own consumption. He didn't sell it, he didn't give it away. He used it for his farm animals, he used it for his family's food source, and he was charged under the federal law for making too much wheat. Well, what the court said was that, well, you know, the Congress, and he challenged the constitutionality of this federal law that said, no, you can't grow that much wheat. And the court said, well, this falls under the Commerce Clause because it has an indirect effect on interstate commerce. Because if Mr. Filburn's not buying, or if he's making his own wheat, then that means he's not buying wheat from others, and therefore he's affecting interstate commerce. Okay, and what the federal government, this is what drives me nuts, because the federal government didn't determine whether this was sound constitutional policy. The purpose of this regulation was to regulate the price of wheat so that farmers could grow it. So the price didn't get too low that no one could afford to farm wheat, and it couldn't get too high to where everyone's food prices went really high. So what the court did not address, and probably should have, is, well, does Congress even have the authority to set prices on goods? But that wasn't part of it. What the court found was he was in violation. The law is constitutional because Mr. Filburn, you know, maybe his portion of you know, a couple acres of wheat didn't really influence interstate commerce, but thousands of small farmers doing the exact same thing does, and there's an indirect impact there. And so that's just one example of how they expanded the Commerce Clause to even include things that aren't commerce. If you're growing your own wheat, you're affecting supposedly interstate commerce. But under that scenario, you could say anything. I mean, you can't grow your own flowers, because if you grow your own flowers, then you're not buying flowers from other states. And I mean, everything. You could argue that if you're singing bedtime stories to your kids, then Congress can regulate you singing bedtime stories to your kids, because you're not buying commercial CDs and albums of people who have a career in making bedtime stories, right? So that's how we got to where we are here. Now, what this did was, so they challenged the constitutionality of the law here. And let me grab I made some notes, all right? Because this is a big case. This case, the book doesn't even have that we went through. It doesn't even have the entire case. It only has 11 pages of the case. The case is much longer. So I went through the actual case. What happened was so he was indicted, Lopez was indicted under a federal grand jury, okay, for violating the Gun-Free School Zone Act. And he moved to dismiss it, Lopez did, because it was unconstitutional, as it's beyond the power of Congress to legislate control over public schools. I agree with that. The district court, however, denied the motion. He went to a bench trial, which means no jury. He waived his right to a jury trial. And ladies and gentlemen, I don't know why you do that. I mean, there are instances, I take it back. There are some instances where you probably want to do that, but for the most part, don't ever waive a jury trial. And then the court concluded that, this is the district court in Lopez, said that, quote, it is the issue or the law that says carrying a firearm within 1,000 feet of a school zone is a constitutional exercise of Congress's well-defined power to regulate activities in and affecting commerce and the business. Let me turn my phone off here. The business of elementary, middle, and high schools. I didn't realize that was a business. I thought it was a government program or education. Now we know that the reason that the government wants you in public education is because it's a business, according to this. To regulate activities in and affecting commerce and the business of elementary, middle, and high schools affects interstate commerce. So he was convicted. He was sentenced to 6 months in prison and 2 years, but the Fifth Circuit, remember this is Jacksonville, Florida. I'm sorry, San Antonio, Texas. I don't know where Jacksonville came from. This is San Antonio, Texas. The Fifth Circuit reversed that conviction, and of course, the federal government appealed to the Supreme Court. Now, I'm not going to go into all the legalese stuff, but I want to tell you what the government argument was. Okay, this was the government argument trying to say why the Gun-Free School Zones Act was constitutional under the Commerce Clause. And they said there were two reasons. First, the costs of violent crime are substantial. And though the mechanism of insurance, and through the mechanism of insurance, these costs are spread throughout the population. The court didn't buy that. I don't either. The costs of violent crime, okay, but violent crime is not an interstate transaction. I mean, obviously organized crime might be, but general thefts, robberies, shootings, murders, those kinds of things, that's not interstate commerce. So I don't even understand how they were able to argue that with a straight face. But second, and this makes a little bit of sense if you really look at it objectively, violent crime reduces the willingness of individuals to travel to areas within the country that are perceived to be unsafe. And it also argues that the presence of guns in schools poses a substantial threat to the educational process by threatening the learning environment. Again, the learning environment is not a commercial activity. Now, the court saw through this, thankfully, okay? The court saw through this. And if you really think about it, though, I mean, there is an argument to be made there that violent crime, I mean, for example, there are places in Texas, there are places in Houston specifically, that I will not go because it's just so incredibly dangerous. Now, I'm in Texas, but let's say that vacationers or tourists are trying to go to Texas and they want to go to Houston. Well, those tourists, which are engaged in interstate commerce because they're coming from out of state to visit our great state of Texas, are not going to a certain place because crime is high. So there's an argument to be made that crimes that involve firearms can definitely affect interstate commerce because people don't want to go somewhere that's unsafe. However, the court thankfully saw through this because criminal acts are not commercial in nature. Okay, they're not commercial in nature. So the holding found that if Congress can, pursuant to its Commerce Clause, regulate activities that adversely affect the learning environment, then it can also regulate the education process directly. That's what the court's saying. Look, if you can say that the education process falls within the purview of the federal government, then what's to stop the federal government from saying what you have to teach, what each state has to teach? Now, it kind of does that today, doesn't it? I mean, this is 1995, but isn't that sort of what the federal government is doing these days by dangling federal dollars and requiring all of this silly nonsense training that kids have to get every year? That's where a lot of the money and the cost of education goes is all these federal mandates. That's why education is so expensive, not because we don't spend enough. We spend more per capita than any other country, and yet we're not the smartest people on the planet. Go figure. Congress could determine that a school's curriculum has a significant effect on the extent of classroom learning. So what the court did was it overruled or it ruled unconstitutional the Gun-Free School Zone Act, at least as it related to Section 922, which is the section that says you can't take a firearm within 1,000 feet. Now, we're going to get to John's question that he said about carrying a firearm within 1,000 feet. But first, a couple of concurrences on this case. There were several concurrences, 2 concurrences, and 3 dissents. All right, and this was a 5-4 decision. A 5-4 decision. So you have obviously Sotomayor, you have Souter, Breyers, and Stevens that voted against this. And I really liked what Justice Thomas, Clarence Thomas, had to say. And I'm telling you, if you follow, or even if you don't follow how the courts rule on issues, Clarence Thomas and I would even say Clarence Thomas more than Scalia were very good at making sure that the spirit of the Constitution, what the founders intended when they wrote these words, even though a lot of times they've been broadly interpreted, is what is interpreted today. And I think Justice Clarence Thomas is probably, I think now he's the only originalist on the bench, but he's also been very consistent. Scalia hasn't really been super consistent, but he's probably the next closest. And so Thomas says, he's like, look, I agree with the decision of the court, but I think we're not really going far enough. All right. He recognizes where the court's gone since the 1930s until today, and it concerns him, as it should, because this was the first case in decades. This was the first case in decades that, because from 1930 to about 1995, the Supreme Court did not overturn that I know of, a single federal law that was challenged on constitutionality based on the Commerce Clause. Why? Because the Supreme Court had watered down the Commerce Clause. First, it must directly affect commerce. Then it was, okay, it can directly or indirectly affect commerce. And then it has to have a reasonable relation to the indirect effect on commerce. And then, or actually first it was a substantial, it must have a substantial effect, indirect effect on commerce. And then it was broadened even more to, it just must have a reasonable, I think the word was reasonable. Where's my notes at? Here we go. I wrote some other notes down here. Reasonable, blah, 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 blah. So the first was a rational basis. It must have, so it was a substantial first, a significant effect. They expanded that it just has to have a significant effect on interstate commerce. It doesn't have to be directly related. It must be significant. That's still somewhat narrow. And then in Katzenbach, it says if Congress believes there is a rational basis that something affects commerce, then the federal government can regulate it. Well, geez, you can create a rational basis for just about anything. And so, there's that. And then here comes Lopez, and finally all that expansion has come to a screeching halt. And so Justice Thomas says, the power to regulate commerce can by no means encompass authority over mere gun possession any more than empowers the federal government to regulate marriage, littering, or cruelty to animals throughout the 50 states. Any interpretation of the Commerce Clause that even suggests that Congress could regulate such matters is in need of re-examination. And what he's saying here is like, look, I agree with what's going on in Lopez. The federal government should not be able to use the Commerce Clause as an excuse to regulate even fundamental rights like this. And he says, what we really need to do is when there's an interpretation of the Commerce Clause that suggests Congress can do that, we probably need to re-examine that, meaning all those cases from 1930 to now, we probably need to start re-examining that. And he actually talked about the fact that the court has been out of control on the Commerce Clause. And I mean, I agree with that. You agree with that. I mean, look at Obamacare. when Obamacare was challenged in the court, the Anti-Injunction Act had been passed, and so the court, by legislative act, by congressional act and law, cannot issue an injunction on an issue or a case that involves taxation by the federal government. So if the federal government taxes you on something, the courts can't issue an injunction until it's heard, okay, until the whole case is heard because of this law. And you know, the Constitution, that's why you got to understand the Constitution. The legislature can put limitations on the courts. And that's what they did here is Congress passed an act, and I don't remember when the act was passed, but they passed an act called the Anti-Injunction Act that told the courts, look, you can't issue injunctions on challenges to taxation because under the tax and spend clause of the Constitution, we're allowed to tax and spend, all right? Now, that doesn't mean that after you've paid a tax, you can challenge it. Now, you can still challenge it, but the court just can't issue an injunction. So obviously, the court in challenging, there were two areas of the Obamacare Act that were challenged in the Sebelius case, and that was the individual mandate and the Medicaid expansion for the states. Well, Congress or the court looked into the Anti-Injunction Act and said, okay, first we've got to figure out, can we even hear this? Because obviously everyone's saying Obamacare is just another tax, and if it is a tax, then we can't issue an injunction because that's what the plaintiffs in the case were arguing. It was for an injunction against the individual mandate and the Medicaid expansion. But so they're like, well, hang on, is this a tax? Is the individual mandate a tax? Because if you remember, if you didn't have insurance, you had to pay a fine or a penalty, they called it. And the court found that no, since the legislation identified what I'm going to call a tax as a shared responsibility fee or a shared responsibility payment, that's what it was. The legislation called it a shared responsibility payment. If you didn't have enough insurance, then you had to pay a shared responsibility payment. And so the court said, okay, now that we've decided that the Anti-Injunction Act doesn't apply here because Obamacare is not a tax, let's go ahead and see if Congress has the authority to regulate and force people to buy insurance. And what the court ended up finding is that, well, yes. Why? Because the shared responsibility payment is just another word for tax. So on one hand, the court weaseled its way saying, okay, we can get around the Anti-Injunction Act because it's not a tax, but it's constitutional because it is a tax. That's how we got that. So Justice Thomas, going back to his thing here, says that the Constitution not only uses the word commerce in a narrower sense than our case law might suggest, but it also does not support the proposition that Congress has authority over all activities that substantially affect interstate commerce. Remember, I was talking about that's where the narrowing came down. And he says, from the time of our ratification of the Constitution to the mid-1930s, there was no question that activities wholly separated from business, such as gun possession, were beyond the reach of the commerce power. If anything, the wrong term was the court's dramatic departure in the 1930s during the Big New Deal. Remember, Roosevelt, he tried to pack the court. One of the things Roosevelt tried to do, because he was so angry that up to the 1930s, the court had historically on 5-4 decisions, delegitimized a lot of these commerce cases. And are y'all talking to Terry? And I don't see. Oh, never mind. You're texting her. Okay. I said I didn't see her on here. What was I saying? Oh yeah. And so what Roosevelt decided to push was, hey, Congress, I want a law that would add another Supreme Court seat to the court for every justice at the time that was over the age of 70. Now that would have increased the court from 9 to 15 at the time, okay, because 6 of them were over 70 at the time. And so this was his way of trying to pack the court. And one of the Supreme Court justices, for whatever reason, all of a sudden switched his position, and the 5-4 majority against the Commerce Clause, against regulation that interfered with the Commerce Clause, suddenly became a 5-4 majority in favor of expanding the Commerce Clause. And that's what happened in the 30s. And that's what Justice Thomas was arguing about. And so then you've got all the dissents, and really what all the dissents said was, feelings, emotions, guns bad. That's what the 4 liberals on the court said. But here's what bothers me, okay? Because in the case, let me find this section. In this case, what the court did was it essentially told the federal government, hey, look, there's nothing in here that says anything about affecting commerce, okay? You didn't, I'm just going to paraphrase, I'm not going to read it. This law is unconstitutional because it has nothing to do with interstate commerce. So what does the federal government do? So the Gun-Free School Zone Act is ruled unconstitutional in 1995. So what do? They rewrite it. I think it was 1998. It was rewritten, and this was during George Clinton, William Jefferson Clinton, excuse me, not George Clinton, that's the singer. William Jefferson Clinton, B.J. Clinton. This was under his watch. They passed an amendment to the Gun-Free School Zone Act. And here's what they did. Now I'm getting into John's question. He had asked a long time ago, earlier in this video, whether, he says, I got a question about carrying my rifle within 1,000 foot of a school because I live within 1,000 feet of the school. All right. The way that they changed section 922, and you can look this up, it's 18 USC, section 922Q, says, so Congress makes a few declarations in the new one. And the reason he did that is, the reason the legislature did that, not the legislature, Congress, is because the Supreme Court in United States v. Lopez literally told them, hey, this law doesn't say anything about how it affects interstate commerce. You're sitting here arguing commerce, but it's a criminal act. You're talking about criminal acts here, and there's no logical relation between just the possession of a firearm and interstate commerce. So the court got snarky, or not the court, I'm sorry, the Congress got snarky. And the Congress found and declared, now keep in mind too, and I'm gonna have to look again, but I know for much of Clinton's term, and I don't know if in 1998 or when this act was amended, I'm trying to remember if there was a Republican majority by that time. But for a long time under Clinton's time in office, it was a Republican majority in Congress while Clinton was president. And here's what it says. Congress finds and declares that A, crime, particularly crime involving drugs and guns, is a pervasive nationwide problem. I don't see what that's got to do with interstate commerce. Crime at the local level is exacerbated, and here we go, listen to the words, is exacerbated by the interstate movement of drugs, guns, and criminal gangs. So now they're making this an interstate commerce. They're trying to wrap around data to show that what they're about to do is related to the Commerce Clause. Firearms and ammunition move easily in interstate commerce and have been found in increasing numbers in and around schools, as documented in numerous hearings in both the Committee on the Judiciary, House of Representatives, and Committee on the Judiciary of the Senate. In fact, even before the sale of a firearm, the gun, its component parts, ammunition, and the raw materials from which they are made have considerably moved in interstate commerce. And it keeps going on, and it talks about this decline in the quality of education has an adverse impact. And they're saying that crime has had an adverse impact on the quality of education. The occurrence of crime in school zones has resulted in a decline in the quality of education in our country. And this adverse impact has impacted interstate commerce and the foreign commerce of the United States. So now they've laid the groundwork of how supposedly the mere possession of a firearm has affected interstate commerce, because just the fact that someone possesses a firearm means there's going to be more crime. And just because there's more crime, that's going to affect the quality of education. And the quality of education is going to affect interstate and foreign commerce. So here's how they rewrote the law. Then they finally go into it in 922Q, or Quebec, subsection 2. It shall be unlawful for any individual knowingly to possess, and what it used to say is knowingly possess a firearm at a place the individual knows or has reasonable cause to believe is a school zone. That's what it used to say. Now, as of today, here's what the law says. It shall be unlawful for any individual knowingly to possess a firearm that has moved in or that otherwise affects interstate and foreign commerce at a place the individual knows or has cause to believe is a school zone. So the answer to Digi's impetus question is, can I carry a firearm within 1,000 feet? The answer is yes and no. If it is a firearm that is moved in interstate commerce, in other words, like for example, if you've got a, I believe the XD is made in Austria. No, the Glocks are made in Austria. It's either the XD or the Glock is made in Austria. Well, hell, I got an XD right here. Let's see. No, this is US. No, here it is, made in Croatia. That's what I meant, Croatia. So if I've got this, this is my XD9. The only reason I wore my XD9 today instead of my 1911 is because it's Constitution Day. And I don't wear, obviously I can't take my guns where I'm going to school, but I've got this nice Texas holster, and I was all patriotic today. Now, I wore a black suit and my Constitution tie, and the symbolism of my black suit and the Constitution tie is that I mourn the death of the constitutional principles that have occurred because of the Supreme Court and how the Constitution has been slowly killed. But I've got several XDs. So if I have an XD, or if I have a firearm that's made in another state, for example, I'm in Texas and I'm carrying a Remington or a Springfield Armory, okay, then no, you may not go within 1,000 feet of a school, except, okay, there are several exceptions here, okay? If you live on private property that's not a part of the school grounds, okay, that it doesn't apply on that private property or going to and from that private property, okay? It also doesn't apply if you're driving through a school zone, just driving through, okay, that doesn't apply. Obviously, if you're a law enforcement officer, if you've got a contract, and the school allows you to, you can, if you don't have a license, if it's not loaded and it's in a locked container or a locked firearms rack that's in a motor vehicle, that doesn't apply. So it's got to be unloaded and locked away. Then it doesn't apply there. And it also doesn't apply, here's the other thing, if the individual possessing the firearm is licensed to do so by the state in which the school zone is located. So if you're in Texas and you have a Texas license, this law does not apply. The Gun-Free School Zone Act does not apply. Now, just because the federal law doesn't apply doesn't mean the state law won't apply. However, for example, in my case, I have an out-of-state license that is recognized in Texas, and that's what I've been carrying on because I have wanted to, I just didn't want to pay for my rights in my state. I want to fight to get constitutional carry, but I also want to be able to carry into certain places I wouldn't be able to without a license legally. And because I'm an activist and I'm always interacting with law enforcement, the last thing I need to be doing when I'm constantly getting harassed is breaking the law, giving them a reason to arrest me. So my license, my out-of-state license, would not exempt me from the Gun-Free School Zone Act because it is not a license that is issued by the state in which the school zone is located. So let's say you have an Arizona license and you're in Texas, the Gun-Free School Zone Act still applies unless your firearm that you're carrying is one that was made and sold in Texas and the school is in Texas, because that firearm has not moved in interstate commerce and it doesn't affect interstate commerce. Okay, so when I do my bike rides, this is what I always did is I've got a Legion Arms rifle, AR-15, that was made and sold in Temple, Texas. I bought it in Temple, Texas. It was the company was in Temple, Texas. They're not around anymore. The rifle says Temple, Texas on it. That's where it's made. And so therefore, because it hasn't engaged in interstate commerce, the Gun-Free School Zone Act doesn't apply. Those are the exceptions. So that's why I said digitus impetus. That's why I said, can you carry within 1,000 feet? Yes and no. It depends. If you live within 1,000 feet of the school, you're exempted. Now you can't just go walking around the school or whatever, but it just means that on your private property, you're fine, and going to and from your property through the school zone, you're fine. If you have a license in the state where the school zone is located, the Gun-Free School Zone Act doesn't apply. As long as, now by the way, it just says that and the law of the state or political subdivision requires that before an individual obtains such a license, law enforcement authorities of the state verify that the individual is qualified under the law to receive the license. So in other words, states can't just give out licenses without essentially background checks, making sure that they're not a federally prohibited person. So as long as they're doing that, the license applies. Private property, if you have a state license, and you're going through that state, or you're in the school zone that's in that same state where you have the license, if you, hang on. But wait, Top, I have firearms in 2 states, Texas and Kentucky. It doesn't matter where the firearm is located. So if you have a Texas firearm and you go to Kentucky, you now have a firearm that has, whether I agree with this or not, because I don't believe that mere possession invokes the Commerce Clause. And I'm still looking for cases where, and that's kind of what they said here in the Lopez case. That's one of the things that the concurring vote, the concurring decisions said. Now, the concurring decisions mean nothing. It's what we call dicta. Just because you concur and then you start saying other stuff, that other stuff isn't case law. The only part that's case law is the decision itself, the opinion itself that the majority agrees to, okay? And when someone writes a concurring opinion, even though that concurring opinion agrees with the results of the case, what's said in that concurring opinion doesn't matter. It's not law. It can't be relied on. Now, that dicta can be relied upon for future cases as persuasive, okay, but it's not something that the court is required to follow. And what they said was, and that's one of the things that Thomas and Kennedy, I wanted to make sure I had the right name, that's one of the things that Thomas and Kennedy argued, was that what the state here is doing is regulating just the possession. There's no interstate commerce there. Now, obviously, the dissents, the liberal minority, argued that, well, yeah, but you can't have a gun unless there was interstate commerce involved, because the gun itself, before you buy it, is, well, that assumes that you bought your gun. What if you made your own gun, right? Well, then there's no interstate commerce there. There's no commerce at all in the gun itself. So if you in Texas, if you have a gun that was made in Texas, and you're in Texas going through a school zone, you're fine. Now, if you take that Texas gun to Kentucky, it doesn't work, because essentially that gun, even though you didn't buy it in Kentucky, you bought it while you were in Texas, and it was made in Texas, and it was an intrastate purchase. The fact that it's in Kentucky, the fact that you possessed it, that has not been determined by the courts yet as commerce or not. I would argue that's not commerce, just the fact that I bought something. Now, if I was in Kentucky and I went to Texas to buy something to take back to Kentucky, that is interstate commerce. And it's all weird, right? If you have a Kentucky firearm that was made in Kentucky and bought in Kentucky, and you're in Kentucky and you're in a school zone in Kentucky, that's fine, unless you're from Texas and you went to Kentucky to buy that gun and you don't live there. All right. So if I go to Kentucky and I buy a gun, but I don't live in Kentucky, my domicile is in Texas, and I try to walk through a school zone and I get stopped, and I go, well, no, this gun hasn't engaged in interstate commerce, and they find out I'm from Texas. Well, it has, because I have traveled between states to purchase the gun. That is interstate commerce. So the Texas gun applies in Texas, and so I mean it's a hard situation now in Texas. So if this doesn't apply, then we get, so as long as we've got a gun that was engaged in intrastate, in other words, my Legion Arms rifle, I can just go into the school with my rifle, right? No, because then you got to look at state law. And under Texas state law, you can walk right up to the front door of a school, and you're not necessarily breaking the law. You're not breaking any possession laws. Let's just put it that way. There might be other laws they're going to try you under. Carrying in a manner calculated to cause alarm, probably, because that is a sensitive area, and a reasonable person would probably know that the fact that someone's carrying an AR-15, even though it wasn't engaged in interstate commerce, up to the front door of a school might cause alarm. Okay, the court would probably find that. Whoops, hang on, I touched my pad and lost my window. A court would probably find that there's some other law that was broken there. So my recommendation: don't carry a gun openly. Now, I've carried my handgun. I've carried my handgun openly, like when I drop my kids off or pick my kids up. I'm not too worried about that because a handgun just sits in a holster, okay? And it's very hard to say I'm trying to cause alarm. Now, what's going to happen is the liberal educators are going to panic anyway because all they see is a gun. They don't look at anything else. All they see is a gun. And they're probably going to panic anyway, but I probably would not get convicted of that because, one, I have a license, which in Texas, if you have a license, you're good. Now, if you don't have a license, it's 300 feet. Okay, if you do not have a Texas license, stay outside of 300 feet of the building. Okay, 300 feet. That's the Texas law, not 1,000, 300 feet. Well, if you don't have a license, the federal law does apply, unless it's an in-state gun. So my point is that federal law says unless I live within 1,000 feet, it doesn't say only on my private property. Yeah, what it says specifically is it subparagraph A does not apply to possession of a firearm on private property not part of school grounds. So it does say only on your private property. It says it does not apply to possession of a firearm, quote, on private property not part of school grounds. So that's the law. That's the Gun-Free School Zone Act. It is 18 U.S. Code, Section 922. 18 U.S. Code, Section 922, subsection Q2. BI. There you go. Q2BI. All right. Any other questions about that? I am surprised I was able to keep this under an hour. But I wanted to let you know there are exceptions, and I use these exceptions. There's a reason why when I'm doing my activism and I'm doing a rally or something, and I'm going someplace that I don't know where I'm going. No, you don't need any license for a long gun, but it's still considered a firearm. And if you have a license, that license exempts, it doesn't say whether it's a pistol or a rifle, it just says firearm. So whether you've got a long gun or a pistol, the law says firearm, okay? Don't think that just because you got a rifle, it's different, and that the law says handgun, it doesn't, it says firearm. So if you don't have a license, stay outside of 300 feet. And if you don't have a gun that is an intrastate purchase, in other words, made in the state where you are, stay outside of 1,000 feet, whether it's a long gun or a handgun. I'm just telling you what the law is. If you want to challenge it, that's on you. If you want to challenge the constitutionality of that, I'm just telling you, you're going to lose in the lower courts, and you're going to have to fight it all the way up to the Supreme Court. Okay. Any other questions before I end this? If you do have other questions, I'm going to try and make a regular habit out of this. I'd like to start talking about different legal principles. I do have a new Facebook page. It's First Sergeant CJ Grisham on Facebook. I don't have a private account there. I I only have a public account now, and I'm using a dummy account to run that one. For some reason, I've got a CJ Grisham, and I've tried to publish it, and for whatever reason, it won't publish. I can't delete it. I can't publish it. I can't edit it. It's my old campaign page. For whatever reason, I can't even use it, and I can't delete it. It's just there. It's annoying as hell. And I can't just call it CJ Grisham because I already have a page that says CJ Grisham, even though I can't publish it. All right, that is Lopez. That is the Gun-Free School Zone Act. It was a whole hour just to get to what the law is right now. And keep in mind, okay, always know your state law about possession of a firearm in and around a school zone, okay, because it varies. A lot of states have essentially mimicked the federal law. There's actually a town outside of, I think it's southwest of Houston, and I can't remember. And maybe if you just here, let me check real quick. So I'm pretty much done. But gun-free Texas town. Let's see, or Texas city. What was it? Maybe it's gun-free Texas city. But there's a city, a small suburb, and I want to say it was outside of Houston, that because the city is so small, the way that they've placed their parks and the way that they've placed their schools, they've essentially created an entire town that is a gun-free zone. So they think, and they're proud of this. They're actually proud of this. I don't remember the name of the town here. I'm trying to. When I was fighting for open carry back in the day, I remembered it. I almost had it memorized. I'll find it later, but there is a city in Texas near, I think, Houston, where they've used the federal law and the state law to essentially, they've got this map on their city page that they're so happy that their city is a gun-free zone because they drew all the circles around all of the different places where schools are. And of course, you know that Texas has given the ability of municipalities to regulate guns in parks if you don't have a license. And so they've also tried to draw circles around all their parks saying that, okay, you can't have a gun here because we're banning guns in parks if you don't have a license. Although they don't really say that. They hope that people are stupid and don't know that if you have a license, their little park bans don't matter in Texas. So there you go. There's the Gun-Free School Zone Act. Did you hear about the guy who was in his house with a shotgun in Minnesota? BLM showed up and the cops arrested. I saw that. Yeah, I saw a video of that. I didn't know he got arrested. I mean, it's I don't, this country is going to hell. But let me tell you something. And I'm going to finish this before an hour. So I've got a minute and 45 seconds to make this point. If you don't think that the police are going to enforce a gun confiscation order, just look what happened 2 days ago when Brent McCain was not wearing a mask at a gas station while buying some water. A police officer came in there, asked him where his mask was, got pissed off that Brent wouldn't kiss his ass, and he ended up in handcuffs. The officer disarmed him. The officer pointed a taser at him because he was open carrying and not wearing a mask. Okay, they ran the gun, and then when all this was over with, they refused to give the gun to him. They walked Brent to his car, put the gun in his holster. When Brent was in his car, door closed, rolled the window down, the officer put the gun on the dash and told him, please don't touch it until I leave. All right. If you don't think that the police are going to enforce gun control laws and exterminate or confiscation laws, all you've got to look is the fact that they're enforcing these mask ordinances. They're pointing tasers at people who are open carrying, and that's just fine. I called the police chief and spoke to a commander there, and the dude was completely rude. Doesn't think the officer did anything wrong. This is where we live, so that's why these are the times that we live in. So make sure you know the law, every single aspect of it. Because I guarantee you, when I was in Gatesville, I was accused of going through a school zone, and I had to educate the cops because I showed them. Well, first of all, I wasn't in a school zone because I always try to avoid school zones. And second is that, look, I've got a gun that was made here in Texas. And yes, the cops are going to enforce any law. All they want to do is they just want that paycheck. All right, guys, take care, be safe, be free, and I will see y'all next time. If there's something you want me to talk about, if there's a legal issue, keep in mind, I am not an attorney. Oh, I guess I should put this on here. I am not an attorney, okay? I did not give you any legal advice. All I'm doing is giving you my opinion of how the case law comes out, a little bit of history about it, and what the law says. If you question anything that I said earlier, go see an attorney. Okay. If you want legal advice, go see an attorney. I am not an attorney. I'm dangerous. I'm a law student. Okay. I'm dangerous, but I do love this stuff. A lot of this stuff I already knew, but I'm just kind of learning the principles of it. And if you missed anything, please share this video. Please subscribe. Please like. If you're able to help donate and stuff, I could definitely use it because my education benefits ran out. And so getting through law school is important because here's one of the things I'm going to do when I get out. And look, I'm already a minute over my hour. Is I am tailoring my law school classes in a way that when I get out and I become an attorney, one of the things I'm going to be doing is helping Texans who are felons get their rights reinstated. Okay. And so if that's something you care about and you want an attorney that's willing to fight for that kind of stuff and not charge an arm and a leg, then I'm the guy you want. So if you can help me ease the stress by dropping a few bucks, you'll see in the description of the video, I've got some links there. I would appreciate it. Okay. But it's personal. You don't have to do it. I don't care. I don't do these videos for money. Just saying. All right, y'all, take care, be safe, and be free.